Well, it's interesting because you mentioned other side and the difficulties of the metaverse, and I almost see a parallel there with the downstream creator economy trying to find a way to use Web3 tools for monetization of intellectual properties. Well, it's a very difficult problem. There's all these regulatory hurdles. There's all these problems that just like a AAA game takes 3 to 5 years to develop, and so there's this fundamental, like, it just takes time. That also kind of happening with the downstream, use and monetization of IP in a Web3 economy. And then leading into the AI usage, which I think is an incredible point and a very timely issue. I know you recently published in the UF Law Journal, which is my hometown law journal. I graduated from the University of Florida Law School. An article titled "Prompting Progress: Authorship in the Age of AI." And so there's all these challenges, and I wanted to follow up and ask you about that article, because you said something there which resonated with me, which is you really critiqued the copyright offices. They had guidance last year on AI generated works, and the stance that basically a work that's AI generated has no human authorship element and is not protectable. And you critiqued that stance, and I think when we talk about the monetization of intellectual property leading into an AI NFT economy, and then that being the gate for autonomous payments and royalties, I think this is also a fundamental challenge to the expansion of that. So I'm curious what your thought process was on disagreeing with the Copyright Office on their stance, and perhaps how that gets resolved from here.
Yeah, I mean, first of all, let me just say I think the Copyright Office does incredible work. They're engaged in an AI
Agree.
study
Yeah.
right now, and I applaud them for their initiative. I think they try to get ahead of the curve on this one, but the position that they had in their AI guidance and in several of their decisions rejecting the copyrightability of prompt engineered AI works. We're putting aside the autonomously generated works where there's no claim of human authorship. I'm focusing on where humans are using prompts to generate an image or generate a song or generate a video, uh, putting aside kind of literary works, which is, I think, presents a separate uh, set of issues.
Hmm.
So my reaction when the Copyright Office started rejecting prompt engineered images was that the position that it was advancing was just simply not supported by the Copyright Clause or the Progress Clause of the Constitution, which grants Congress the power to give exclusive rights to authors for their writings. And the Copyright Office was interpreting authors to implicitly have a requirement of so-called traditional elements of authorship. That's a term that no federal court has ever used in describing a requirement of authorship. It's a creation of the Register of Copyrights, Kamenstein, back in 1965 in an annual address, and it was more of a tentative comment about computer-generated works. And then suddenly the Copyright Office has revived it with AI. And even if this were sort of had a more solid pedigree of where it came from, I think on the substance, it is just wrong because the Constitution, the Progress Clause or Copyright Clause, is meant to. Congress has the power to promote progress, which is progress is like a forward-looking thing in the future. We want advancement of knowledge and creation of works to advance that knowledge. And the word author is general, it's not limited. And one of the things I point out in my article, the Florida Law Review article, is the framers actually had a choice. Madison proposed literary authors. Edmund Pinckney proposed authors. And Pinckney also proposed a different clause for seminaries that had a more capacious goal of promoting science and the arts and literature uh, in in the copyright clause or in the progress clause, it's to promote the progress of science and the useful arts. So, given the more kind of broad or general terms that the framers ultimately adopt in the Constitution, I think it's completely incorrect or wrong as a constitutional matter to impose traditional restrictions on authors.